The next case is in re OB. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I will be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the name of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Thank you, Your Honor. I'll reserve 5 minutes for rebuttal. Neil Iredell on behalf of the appellant father in this matter. Your Honor, the facts of this case is not in any dispute. It's factually speaking, it's a very simple case. Children's Services filed a complaint making a number of allegations of abuse, dependency, neglect. We had an adjudication before the magistrate which found dependency. It was affirmed on objections. It was appealed to this court, who found that the trial court's decision was against the manifest weight of the evidence. Basically, on the merits, the agency failed to prove its case. And then I'm not sure I understand why, but the court remanded it back to the trial court. I, on behalf of the father, then filed a motion to dismiss with prejudice, saying it's against the manifest weight, they couldn't prove their case, they have
manifest weight and not prove their case is different. I mean, not prove their case seems like sufficiency to be a manifest weight. When we send back, we normally send it back with the permission for the court to hold another hearing and for them to have another case.
I would disagree, Your Honor. If it's against the manifest weight, that means the evidence that they proved at adjudication was not proven by clear and convincing evidence to prove a finding of dependency. Okay, and it was remanded back. I filed a motion to dismiss with prejudice, saying, they didn't prove their case. They could not prove by clear and convincing evidence. And the trial judge, rather than granting the motion, set it for a hearing, which is fine. In the meantime, before we had a hearing on my motion to dismiss with prejudice, CSB filed a secret motion to dismiss without prejudice, and they italicized in their motion without prejudice, and they gave proposed journal entries to the magistrate and trial court to say dismissed without prejudice, also italicized. And within 20 minutes of CSB filing their motion, the trial court and the magistrate granted the motion to dismiss without prejudice, and CSB then the same day immediately filed a new complaint alleging the old facts and the new facts, and the parents and the guardian, everyone's like, wait, what happened here? We don't know anything about this. So we immediately appealed, saying you can't dismiss a case without prejudice after you already lost on manifest weight. Otherwise, you have no finality to this court's decision. Every time CSB loses a case before this court on manifest weight, sufficiency, well, however you want to say it, they say, you know what, we'll just dismiss without prejudice, and we will retry it again on all the grounds that we could fail to prove the first time around.
Counsel, manifest weight and sufficiency are two different things, you agree?
I agree.
Okay, so by its very terms, a manifest weight reversal sends the case back to the trial court for a rehearing on the facts alleged in the same complaint, is that correct?
I don't agree with that premise, Your Honor.
Okay.
Sufficiency, manifest, however you want to define it, CSB did not present clear and convincing evidence of dependency. And when you look at the prior Court of Appeals decision, Justice Stevenson, you wrote a concurrence, which I thought was very apt. It basically says, I could have found dependency if they would have proven this. I could have found dependency if they would have proven that. I could have proven dependency if they would have proven any of the allegations of their complaint. I think the facts could have been sufficient to prove dependency, but they didn't prove anything. So I agree with the Court of Appeals saying, I agree with my colleague, that the decision is against the manifest weight. So I'm arguing there's a lot of procedural and substantive things that are wrong here. One is, we have the law of the case doctrine, we have issue preclusion, we have claim preclusion, we have res judicata. What aspect does that apply to this court's decision saying it was against the manifest weight if it's dismissed without prejudice?
That would be all raised in the new case. I mean, theoretically, in the new case, they come forward, you could raise law of the case and say you can't raise it here, you raise judicata in that new case that they filed. Here it's just, to me, trying to determine whether or not the court properly said without prejudice or with prejudice when they issued their order. And I know that the things raised, I think, are raised in the newer case and not this case in my opinion.
I cannot raise them in the new case, Your Honor, because if I don't appeal the dismissal without prejudice before the trial court, then in the new case, they'll say, well, you didn't object or appeal that the prior case was dismissed without prejudice, so therefore you're stuck with that argument in the new case. I can't argue in the new case that the prior was all res judicata when I did not object to the dismissal without prejudice. So I'm caught in the catch-22. How can I raise in a new case if they start bringing up all the old facts and I start saying, Your Honor, this was all litigated, it's all res judicata, and they'll say, oh, but we have a journal entry that says the prior case was dismissed without prejudice, and you did nothing to object or appeal that decision, that's on you. So we can bring all the prior, because what is the purpose of a dismissal without prejudice? It means as if the prior case never occurred. The last 3 years where the child was in the agency's temporary custody never occurred. The interference with the parent's parental rights for the last 3 years never occurred. Because that's what a dismissal without prejudice is. You put them in the same position as if the complaint was never filed. So how would I raise in the new complaint all res judicata, law of the case, issue preclusion, all of that, when I did not object or the parents was okay in a legal sense of a dismissal without prejudice? The only way I can do it is bring it before this court saying you can't do that. There's no authority. There's no lawful authority. And what is CSB's justification for a dismissal without prejudice? They say, well, we couldn't hold an adjudication and a disposition within a 90-day time frame, so therefore we have to dismiss without prejudice. And I'm like, wait, what? What adjudication? What disposition? You've already had your adjudication. You've already had your disposition within a 90-day time frame. It was found that you couldn't prove your case. It was against the manifest weight. Therefore, you lost the case. If CSB has new concerns post all of this, they are absolutely free to file a new complaint based upon new allegations to prove, but they didn't have that. All they had were the old allegations, so they said, you know what, we'll just dismiss and then file all the old claims, and everything that Justice Stevens says that we failed in proving our case, we'll correct and fix the second time around. So we can have as many bites of the same apple as we want. So let's say we have a second adjudication, and they again prove before the trial court, and I come before this court, and again it's against the manifest weight on the same evidence. Guess what? We'll dismiss without prejudice and try a third time or a fourth time. There is no finality to this court's decision if the trial court could just say on remand, we'll dismiss it without prejudice. And again, we're not saying it can't be dismissed. We're just saying the two words which are extremely important here is without prejudice. It has to have some conclusive effect. Okay? So above and beyond the law of the case doctrine and res judicata, however you want to say it, this prior decision has conclusive binding effect on all future filings involving this child at the juvenile court. Okay. My next issue is, what is CSB's authority and the trial court's ability to grant a motion to dismiss without prejudice? They don't cite anything. They don't make any realistic legal argument. They just say we want it without prejudice. And again, 20 minutes later, it was granted. No testimony, no witnesses, no evidence, no hearing, no affidavit. It was all done ipso facto. And the parents who know nothing about this are all left in the dark. And they say, well, the certificate of service says it was served on them. Well, I know it's not on the record, but not only did we not get it, but in the 20 minutes between them filing it and the trial court granting it, where are the parents' ability of due process to be heard, to get reasonable notice and be heard in a reasonable time to object to any and all of this? Shouldn't the trial court at least have held a hearing, or the magistrate saying, should this be dismissed with or without prejudice? Let's take some testimony, let's find out, let's hear some arguments, let's decide, rather than just be granted and refile a new complaint. And with the old facts. So again, nothing they're saying makes any sense to me.
Just a warning that you're heading into your rebuttal time in about 20 seconds.
Thank you. I just want to say, also due process means not only notice, but you have a right to respond in a reasonable manner in a reasonable time. Where was the parent's reasonable opportunity to respond to this motion to dismiss without prejudice? And finally, I'm arguing not only procedural due process, substantive due process. This totally shocks the conscience. It makes no sense whatsoever, and the state didn't respond to that argument whatsoever in my brief, and I'll reserve the rest of my arguments for rebuttal. Thank you.
Thank you.
May it please the court, Kevin DiMartino on behalf of Summit County Children's Services, the appellee in this case. We are asking that this court affirm the trial court's decision to grant the motion to dismiss without prejudice in this case. I guess I'll start off by saying that a lot of the arguments that are raised by the appellant, I agree with the court that they should be raised in the new case. The docket in this case ends with the court granting the motion to dismiss without prejudice. The new complaint is not in the record.
Well, isn't this an adjudication on the merits of the issue of adjudication? So wouldn't it be, shouldn't there at least be some thought that it could be with prejudice? And if you wouldn't that leave CSB the power to file a whole new, refile a new complaint with the exact same facts, and the parents would have to litigate that all the way through again?
So yes and no. Yes, the agency could file a new complaint, but no, it would not be based on the same facts.
But they could,
It would,
theoretically, if it's without prejudice.
I suppose in theory it could, but I don't agree that that would ever happen. One, in the motion, when the agency asked to dismiss without prejudice, it stated clearly in the motion that it would argue new facts. The agency never intended to relitigate the same facts.
So if this were a civil case and there was a trial on a contract and it was reversed on appeal?
Well, Civil Rule 41 would apply in a civil case. It does not apply here because of the case law, because it says a case about the status of the children. But I understand where you're going.
Right.
The civil rules would prevent that.
So isn't that the same thing here? Similar?
It's similar, but it is different because case law and the intent of the statute is to look at the status of the child on a given day, and specifically the civil rules with regard to this particular area of the law do not apply. So with regard, I agree that we could have, if this case had been dismissed with prejudice, the agency, I say we, I mean the agency, we could have filed another complaint. To be honest with you, it seems a little bit of illegal splitting the hairs as far as what is actually the effect in this particular case on with prejudice or without prejudice, because either way, a new complaint was going to be filed. But I just want to, and I did not mean to cut you off, I apologize if I did, but I do just want to say for the record that he is over here saying as fact what the new complaint said. I don't know what the new complaint said. The court doesn't know what the new complaint says because it's not part of the record. So I don't think it's fair to keep saying that the agency could do this or the agency did that when there's no evidence of it. The only evidence in the record is that the agency intended to file a new complaint based on different facts. That's what we have before us. So this case should be decided on.
But what about his argument that if you had different facts or more facts, you could file a new case? But that could have included the old other facts.
That would be, the agency agrees those new facts, the old facts, excuse me, would be barred by res judicata. We would not include that in the new complaint, other than perhaps as part of the history of the case, but it wouldn't be a new basis to say that the status of the child was dependent.
The dismissal with prejudice sounds like simply prevent you from filing the same complaint on the same facts.
I agree.
Well, isn't that a substantial right to the parents to not keep having to litigate the same set of facts over and over? I
would agree that parents have the right to not have to relitigate the same things, but I do not believe that the issue here is, did the court abuse its discretion in granting a motion to dismiss without prejudice instead of with prejudice? That's the only issue here. right? The issue of whether or not it affects a substantial right is what gets him into court right now and says it's a final appealable order based on precedent out of this court where the most recent, I think, was in Ray E.H., which dealt with the agency had filed a motion to dismiss without prejudice on a case where we thought we had a service issue. The Court of Appeals issued a decision that rendered that issue moot, so we then asked the court to vacate the dismissal, which the court did without prejudice, and the court here said that is a final appealable order. But the court did not say that a juvenile court lacks the authority or the ability, or whichever, word appellant wants to use. It did not say that the trial court, a juvenile court, cannot issue a decision without prejudice in a dependency, neglect, abuse case. This court has not said that. No other court has said that. I understand that Juvenile 22 says that with the permission of the court, we can dismiss a case, and it does not look at with or without prejudice. But there are a lot of cases out there that have dealt with dismissals without prejudice. I also understand that this is kind of a unique situation where there has been a decision rendered on the merits. This court said it was against the weight of the evidence for there to be a dependency finding, and it went back. Most of the other cases do deal with dismissal without prejudice prior to adjudication, and that really does put this in a narrow little box. But based on the record in this case, there's nothing to support appellant's parade of horribles that the agency would just keep relitigating the same facts. The agency did not indicate an intention to do
Then
that.
why seek dismissal without prejudice if you don't want to go back to those same facts?
And I can't answer that. I can only answer what's in the record, which is that it was filed without prejudice. My guess is that because this child has been in at least the temporary custody of the agency for 2 years, the agency wanted to maintain the status quo for this child and not have to go through a case is closed, we no longer have temporary custody, we pull the child from their placement, put them back with their parents, we know we're gonna file again.
Wouldn't that have to happen unless you file quickly thereafter, whether you submit with or without prejudice? There's going to be that break in time. So
Right.
if you don't want to go back and argue the old facts, why are you objecting to dismissal without prejudice?
We're arguing on the basis that the court has the authority to do it, to dismiss it without prejudice. I don't want to foreclose the ability for a trial court to dismiss without prejudice in every instance, because in one particular instance, one appellant is going to come before the Court of Appeals to say, this could be the way things are going to come down the road. This court can set forth a decision that's narrowly tailored to say, under these particular circumstances, in a juvenile case, looking at the statutes that apply to a juvenile case, which are to protect the children and the best interest of the children, and looking at the status of a child on a given day, the trial court has the authority under Juvenile 22 to dismiss with or without prejudice, and here are the parameters of it. But to foreclose it completely is not the appropriate remedy here. For example, when we had issues with service, and we have procedural issues where we had to dismiss without prejudice to immediately refile, if this court was to put out a bright line rule like the appellant is asking for, we would have had to start all over in all of those cases, which wreaks havoc on the children. I understand that it is a substantial right that is being impacted of parents when children are removed from their care, and we're working the case plan, and we're trying to help get everybody back on track for the best interest of the child. I understand that. But we have to always remember when we're looking at these cases, the focus is on the child, and it's on the status of the child on any given day. With regard to the other arguments, I suppose, with res judicata, issue preclusion, claim preclusion, those absolutely are necessary to be raised in the new case. This court does not have any of the information with regard to the complaint before it to say that it is res judicata or issue preclusion or claim preclusion. I do not know. As an officer of the court, I do not know what the new complaint says. All I know.
We keep talking about the new complaint, but the issue isn't he saying the parade of horribles could happen?
He is.
And that's the problem, is maybe right now you're saying we aren't gonna do that, of course we're not gonna do that.
Right.
But the point of this, of dismissal with prejudice is to ensure that they don't happen and that people's rights are honored, correct?
Correct. But even if it was dismissed without prejudice, right? If we had gone that route, we could still file a new complaint.
But it would have to have additional facts.
It would have to
Or
have
else there's gonna be a
additional facts.
motion about, this is the exact same complaint, it's already been litigated, there's dismissal with prejudice. And that would happen at the onset of a case, new case, that's not
And this
A whole
is
new case
technically in a new case also, even though it was dismissed without prejudice, a new case was filed.
Because the rights are already being violated because they had to appeal it, and it goes back, and they've already been working a case plan and having a dispo. So they've already been in the, because there was never any proper adjudication of dependency. So we have parents who have already gone through, pretty much through a case plan and a timeframe, don't get an answer on appeal, and then then the court's gonna say it's okay to dismiss it with prejudice, and then start a whole new case and the litigation all over on the same complaint. And I mean, isn't that more than that's a possibility here if we say this is a dismissal without prejudice?
In this particular case, because the motion said we would proceed on new facts, I don't think that is a possibility in this case. So I think that what we have to look at is very narrow. Does the trial court have the authority to dismiss without prejudice, yes or no? And not look at the possible, things that could happen. Just look at what is the authority of the trial court? Did the trial court abuse its discretion? So with the facts that the court had, and it's also important to remember, I understand that he asked for it with prejudice, but father did ask for the case to be dismissed. The agency then asked for it to be dismissed. There was no objections or anything filed afterwards. They went straight to the appeal. So that is the procedural history that we're looking at here. With regard to,
So if I understand Mr. Eggles' part, I'm not going to speak for him, but I understand him to be saying, when this went back on manifest way, the court could not have heard the same case again on this complaint.
on this complaint, correct?
And you agree with that premise, that when this went back on manifest way, that the trial court could not have just said, we want to have another trial on this complaint?
I don't know that I agree with that. I know that the record contains evidence that the agency did not intend to go forward again on the same complaint. Because
You would not necessarily agree with the conclusion that if the agency had said, we want to go back with the same complaint, that they were precluded from that?
I would not
Based upon our
disagree.
decision.
I agree. I do agree with that.
And that's, I just want to see if you were saying you disagreed or not with Mr.
I
Agarwal. Why you
disagree.
intend to be saying they were not permitted to go back and on this complaint?
I disagree because it talks about the status of the child, and I also disagree with his contention that we would have to wait until, I think he said, quote, all of this was done to file a new complaint. Anything that happens after the date of the initial complaint could be the basis for a new complaint. So if anything had happened during the course of the case plan, that would give rise to the child being dependent, and I don't know if there was, because I don't know the ongoing custodial history of the child, et cetera, throughout the case, but any of that could have also posed a basis for filing a new complaint. So I believe that procedurally, this court, one, needs to determine if the trial court has the authority under the juvenile rules to dismiss without prejudice, and if the court does, whether the court abused its discretion in this particular case, which the agency would argue that it did not, and then, based on whatever's in the complaint, the new complaint, that would have to be litigated in the new case based on the new complaint if there are issues that relate to law of the case, res judicata, issue or claim preclusion.
As far as the court discretion, how should we look at the court's extremely quick decision to grant the motion after it's filed by the agency? I mean, certainly it doesn't seem like they spent much time exercising their discretion, heard from anyone who had an interest in this matter. When there was a hearing 2 days later, it wasn't like there were no hearings set. They could have brought everyone to say, what do you think about this? This isn't certainly a clear situation or rule that says this is what must happen. It's an open question.
I agree. I don't believe in this case the court abused its discretion because it was remanded. Father had asked for the case to be dismissed. Then the agency moved for it to be dismissed. I don't believe that the court had any inclination that father felt that there should be a hearing on just that issue of whether it's with or without prejudice, because regardless of whether the order was granted with or without prejudice, the practical impact would be exactly the same. The agency was going to file a new complaint based on its motion on new facts. Like I said, I don't want to misrepresent what's in the new complaint because I don't know, but the assertion was we're going to file the new motion on new complaints. So even if this court was to say, the trial court erred in dismissing it without prejudice, it should have been dismissed with prejudice. As long as the complaint had new facts, there's no practical impact that it would have been different. Father wanted the case dismissed, the agency wanted the case dismissed, and a new filing is going to come in. And I believe the only reason the agency asked for it without prejudice was to just maintain that status quo for the child. That's my personal belief. It's not in the record. The record is very limited in this particular case as far as there's a motion filed by father, there's a motion filed by the agency, and then there's a very rapid filing with regard to the new complaint, which makes sense, just as you were talking about earlier, Judge, right? We've got a child that's in our custody, and we've got to maintain that status quo. Otherwise, it's very disruptive. Are we going to stop, return the child to who? The person that the child was removed from, which would be mother, which of course then has father, who's been having rights for, visitation and other things, to feel like their rights are now somehow being trampled because they may have less rights than they did during the case in that little bit of time after a reversal. So in the interest of the best interest of the child and looking at the status of the child and applying the case law and the juvenile rules and the case law with regard to the limitations on the application of Civil Rule 41 to these type of cases, based on all that, the agency would ask that this court affirm the trial court's decision to dismiss this particular case without prejudice.
Counsel, I just want to make sure that I'm clear. Are you arguing that the dismissal didn't leave the parents in a worse position than they were when the case was originally remanded, so their substantial rights weren't affected?
I believe they were, yes. I don't believe that they were in a worse position at all. They were, if anything, in the same position. Are there any other questions? Thank you. I rest on my room.
You have 4 minutes and 42 seconds.
Thank you, Your Honor. May it please the court. Your Honor, if you look at my appellate brief, page 14, top paragraph, I say from the Ohio Supreme Court, a dismissal without prejudice leaves the parties as if no action has been brought with respect to the parties dismissed. A dismissal is not an adjudication on the merits and is therefore without prejudice. A dismissal has no effect on the underlying duties, rights, or obligation of the parties. Neither res judicata nor claim preclusion would bar CSB from filing a new complaint on the same grounds. So CSB saying on one hand, we agree with everything Attorney Agarwal said about issue preclusion, claim preclusion, that if he would raise these in the new case, we would agree it's all barred. But if I make that argument, this is res judicata, Your Honor, based on the prior case, and they say, well, let me look at the prior case. Oh, here's the journal entry, dismissed without prejudice. At what point do I make that argument? Well, the dismissal without prejudice was defective. Would they say, well, did you object or appeal that decision in any way? No. Then you're stuck with that decision, a dismissal without prejudice. And they're saying, we would never do that. Trust us, Your Honor. We would never file a new complaint based upon the dismissal. But then Justice Stevenson asked a very important question. Why would you ask for a dismissal without prejudice if your intention is only to file a complaint with a new fact? Her answer is, I don't know. I don't know why we would do that. So, again, CSB is talking out both ends of their mouths. We want a dismissal without prejudice, but we agree we wouldn't do something like that. That would be improper, and it would be...
Well, I think the argument is, to some extent, we're concerned about a very wide case, in this case under Rule 22, that says the agency cannot dismiss without prejudice. Under certain circumstances, it seems reasonable that they can. If they haven't got service or other things going on, there's been no adjudication on the merits, as you're arguing here, you would say, well, sure, they can dismiss without prejudice, no problem. And that's their concern, it seems to me, in part, is that we don't want case law out there saying under Rule 22 we can't dismiss without prejudice, when we ought to be able to. You, I think, are asking for just a narrow rule that says once a decision is reached on the merits, then the court, then it can't be dismissed without prejudice, the court has to dismiss it with prejudice.
It's like a summary judgment on a civil matter. Right after you get a party gets summary judgment, the other side, you know what? Well, we're going to dismiss it right away, so that summary judgment has no effect, and we'll just file a new complaint. I mean, again, they had their trial, they lost. Now they say, we'll forget that trial and we'll start all over again. And trust us, we would introduce new facts. And I can't argue before the court that they did file a complaint with the same facts because it's not in the evidence. But they dismissed it within 20 minutes. Now, getting to the question of 20 minutes, Your Honor, if you look at page 20 of my appellate brief, the Ohio Supreme Court, in a similar rule, which is Civil Rule 41A2 for dismissals in civil cases, the Ohio Supreme Court says, the present case involves a dismissal under Civil Rule 41A2. given the need for the trial court's action in order to effect the dismissal, the opposing party to the action is entitled to be heard on the motion. Failure to afford that opportunity can constitute reversible error. This is the same thing. Juvenile Rule 22 says you need to file a motion, it has to be granted. It's not ipso facto, it's not like a withdrawal, we're just withdrawing our complaint. They do not have the ability to withdraw their complaint. They have to get court permission. As such, we are entitled to be heard on their motion. And they're saying we're splitting hairs. Absolutely. There is a huge difference between a dismissal with and without prejudice. Or, as lawyers, we're here because of legal technicalities. But they're saying, trust us. We will never file a complaint on the old facts, even though we absolutely could. And if we did, he can raise new arguments that is all barred by res judicata, but they're not. Because the journal entry that they would introduce to the trial court says dismissal without prejudice, and what are we supposed to do? Then say, that has no meaning? What effect does this court's decision have on the lower court? And she's saying, well, we both asked for motions to dismiss. That's true, but mine was with prejudice. Theirs is without prejudice. She failed to mention that a few times. So I'm asking the court to and it is a very narrow ruling. If you had an adjudication on the merits, and it is remanded back, and they want a dismissal, it has to be with prejudice. They cannot file a new complaint on the same facts that they lost on the manifest weight. And that's all I'm asking for. I'm not asking that they can never, in fact, they ask for dismissals all the time. Defective service is not held within 90 days. We don't have service. I mean, that's perfectly okay, and I'm not here arguing otherwise. But how does it make sense to go through all the rigmarole of a trial and then come back and say, forget that trial. We're going to start all over again and raise the same facts because we could. And trust us that we won't.
And your time is up.
Thank you, Your Honor.
Thank you. Thank you both for your presentations. The court will take this matter under advisement and issue a ruling in due course. The clerk, of course, will mail you a copy of the decision on the dates released, and the opinions are posted on the Ohio Supreme Court